Thank you. Sir William Cash.
Thank you very much, Mr. Speaker. The first point I'd like to raise is regarding the Ministerial Code and the actions of the Prime Minister. It is quite clear under the Ministerial Code, and I'm glad to see the Attorney General is sitting here on the front bench, that the law officers must be consulted in good time before the government is committed to critical decisions involving legal considerations. Now, even if I was prepared to concede, which I'm not, that it follows that the law officers don't necessarily have to divulge their opinions, though actually he's been obliged to do so by a resolution of the House on the 4th of December in the past. The question is, as a matter of fact, which the Prime Minister today and 2 days ago has resolutely refused to answer me, did the Prime Minister consult the law officers as a matter of fact? I asked her and she refused twice. The inference is that she did not. Is this not misleading the House? That is a question which worries me intensely. Mr. Speaker, having dealt with that issue, which I regard as very serious, I also have to say that I take the strongest possible objection, as do many other distinguished lawyers, QCs and former judges, to the action that has been taken by the government in purporting to enter into a binding agreement in international law which purportedly alters the UK's exit date from the European Union in advance of the votes by each House on the draft regulations, which would create an alteration to exit day in the European Union Withdrawal Act 2018. It has been suggested, Mr. Speaker, that the Act requires that the draft regulations can only be submitted to each House for an affirmative resolution once the date of exit has been altered at international level. This is simply not correct. The provision for approval by affirmative resolution is a freestanding provision in Schedule 7, paragraph 14, under which a draft instrument is to be submitted to the House. It was incumbent on the government, Mr. Speaker, to respect the normal practice of allowing Parliament to approve any legislative changes before entering into a binding international obligation. Mr. Speaker, I was the Shadow Attorney General during the Iraq debacle, and I have to say, Mr. Speaker, that on that occasion it became apparent that there should have been consultation with Parliament on a matter of the gravest national importance. And the reality is, if I may say, obliged or created the circumstances in which the then Attorney General submitted his opinion to the House. We had a similar situation with regard to the issue of the bombing of Syria more recently. So the idea that Parliament is not required to approve any legislative changes before entering into a binding international obligation is well established recently in precedent. The course taken seeks to present Parliament with a fait accompli, in which Parliament is pressured to approve the draft regulations because failure to do so would cause disconformity, it is alleged by the Minister just now, between the UK's international obligations and domestic law. Under our constitutional law, Mr. Speaker, the power of the United Kingdom Government to conclude binding agreements with states and other international actors, such as the European Union, exists under the royal prerogative. It is a basic principle of our constitutional law that the royal prerogative may only be exercised consistently with the intention of Parliament. Any purported exercise of that power, of the royal prerogative, that is inconsistent with the intention of Parliament, is unlawful and of no effect in our internal legal order. I am troubled, and this is why I asked an intervention, as to what the outcome was of the Joint Committee on Statutory Instruments today, and I made the reference to the question of whether or not there was proper consideration of the question of whether or not it was intra-vires or ultra-vires. I do not know the answer to that question, but it's because I haven't been given the information. And I asked the Minister to check whether that was the case. Did they consider the question of vires in relation to the issues before that committee today? Now, the intention of Parliament, Mr. Speaker, is to be found solely in Acts of Parliament. It is not shown by resolutions of the House of Commons, unless an Act of Parliament itself says otherwise, such resolutions in practice do not have effect. Under the principles of public international law, a state is entitled to invoke the fact that its apparent consent to be bound by an international agreement has been expressed in violation of a provision of its internal law, if the violation is manifest, defined as it happens in the words, quote, objectively evident, and concerns a rule of internal law of fundamental importance, and I refer here to Article 46 of the Vienna Convention. These criteria are clearly satisfied, so that on the face of it there is a manifest violation of our internal constitutional law. It is completely and totally unlawful, and it is absolutely abominable that we should be faced with having to vote on the specious grounds of a so-called uniformity, which the Minister has put forward. I don't blame him personally, because, quite frankly, I forgive him. I ask him to forgive me for suggesting that he's taking advice from other persons who are purporting to be learned in the law. But I'm afraid they are entirely wrong. That is the point. And Lord Pannick himself only yesterday raised these very questions himself. And Lord Pannick, of course, is a most distinguished lawyer. In fact, he was the lawyer for the plaintiff, Gina Miller, in the case which required the Act of Parliament, the Notification of Withdrawal Act. Lord Pannick knows what he's doing. In fact, I go so far as to say I actually instructed him with others in relation to the Rees-Mogg case back in 1993. So I know a little bit about the brilliance of Lord Pannick. Lord Pannick says the legal concerns which some lawyers have expressed is that the power to specify the day and time when the treaties have ceased to apply is not satisfied by identifying two possibilities. It is not possible, if this SI is enacted, to identify exit day simply by reading it. He draws attention to this point, but I think it is worth considering the fact that Lord Pannick is not to be taken for granted, and indeed, for that matter, the Lord Pannick has raised serious doubts about this matter, Mr. Speaker. I'll certainly give way.